You're alive. Where's this going? Wow.
This is the House Committee on Commerce and Economic Development. It is Thursday, March 13th, 2025 at 2:27 in the afternoon. We're back from the floor. Apparently it was very entertaining. And now we're to continue our discussions on H 342. And so I don't have my computer on yet, but Garrett is our next presenter. Garrett, good afternoon. Thank
Good
you for
afternoon,
joining
everyone.
us. Great.
You can all hear me okay?
Yes, we can. Thank you.
Great. Thanks, everyone. Good afternoon. I'm Garrett Rogers. I'm a senior operations counsel with First American Title Insurance Company. First off, thank you to the chair and the committee for the opportunity to testify today. I appreciate you guys getting me in sort of last minute. Little bit of background about First American Title Insurance Company in case you're not familiar with title insurance. First American is a national title insurance underwriter. We operate both out of our direct offices and agents, independent agents. And if you look at the state of Vermont, we're primarily operating through independent agents, many of whom are small businesses located in Vermont. Title insurance is a critical component of the home buying process, as well as home financing and home refinancing. As if any of you have purchased or refinanced a home, you may be familiar with how a title company gets involved with that process. But primarily, when a person wants to buy, sell, or refinance a property, they'll engage with a title insurance company to both insure the transaction as well as handle the escrow, which is the disbursement of funds, paying off tax liens, paying off existing mortgages, all those things that kind of clear title to ultimately accomplish that person purchasing or financing that home. So you may be asking, well, why are you here today? And I know there have been some questions. I guess there was a mention of a Delaware situation. I'm not familiar with the Delaware situation, but I might be able to provide a little bit of color as to how some of these data broker issues could impact an individual's ability to purchase or finance a home. And I know we've had some testimony about some of the other types of services that rely on data brokers. But I will say that as a title insurance company, we do rely on data brokers. Not all are defined as data brokers in all states, but in the state of Vermont, we do rely on data brokers that primarily operate with real property data. And if you guys are familiar with that term, that's data obtained from county recorders and county assessor offices. So when a title company is going to issue or underwrite a home purchase or refinance, they, in some instances, will access a data broker who aggregates real property data, so they can examine that real property data. Many other, as has been mentioned, many other participants in the real estate ecosystem, lenders, servicers, real estate agents, to some degree also will look to data brokers who are really real property data aggregators to help streamline processes and do various functions. I don't have enough time today to get into all of it, but certainly other participants like lenders and servicers rely on data brokers to some degree. And First American in particular, we rely both on third-party data brokers and affiliated data brokers, so data brokers that are affiliated with our title insurance company. So with that, I'll pause there for a moment, just with that very brief background, and see if there's any questions.
Garrett, how is your business, or can I hear a little bit about how long data broker services have been a part of your organization's operations? Is that something that's emerged in the last 15 years, 20 years?
Yeah, absolutely. I mean, certainly if you look back 5 to 10 years, I mean, the concept of a data broker didn't exist. But in many states, the title, what we call title plant or real property data companies, are not characterized as data brokers. And the reason they're not characterized as data brokers is because they only deal in publicly available data. That's county recorder and assessor data. So in many states, when I say data broker, I think I'm using that term kind of generically, because in many states, those providers are not qualified as data brokers, but in Vermont, they would be. And I hope that answered your question. And certainly in Vermont, if we look at Vermont, I think we operate primarily through our independent agents. And speaking frankly, Vermont's probably a little bit behind some other states in terms of what I call real property data aggregation and like title plants. But certainly, it's something that companies like First American are always looking to digitize and make that process of issuing and underwriting faster, cheaper, and better for the ultimate consumer. And I'll kind of launch into our comments, but I'll start by saying off the bat, we support redaction laws. We want to support this law. We deal with redaction laws in various forms throughout the country, and we are absolutely in support of those. And we are all for protecting judges and police officers and other public servants. So the things I'll mention today are really probably different than some of the other comments you've had today. We really just have some technical asks, some technical changes based on our experience, especially in New Jersey. And I'll touch on those very briefly. I think many of them have already been mentioned. One that was mentioned very briefly, but that has not really been highlighted, is the concept of what a request needs to look like. So if you go to page 6, in particular line 15 of the proposed bill, it says the notice set forth in subdivision 2 of this subsection shall be in a form provided by the Secretary of State, et cetera, et cetera. One significant challenge we faced, especially in New Jersey, is we deal in real property data. So we received literally thousands of requests in New Jersey that did not include the address of the covered person. So you can imagine a scenario where you get a common name. So you get a common name, Joe Smith, and a telephone number. Well, we don't have telephone numbers. So we have no way to identify what property Joe Smith lives in, whether it's his primary or secondary address. So, and we saw this thousands and thousands of instances of this in New Jersey, and it made it very, very difficult for us to identify the property and get that property, shielded. So what I think is a very simple technical ask is that request that would be in the form provided by the Secretary of State, I would love to see the law actually state that request must include the name, primary address, and secondary address that covered person would like to see, not available for distribution. I think it's a pretty simple ask, but as we've seen in New Jersey, that is not how it's gone. We've gotten all kinds of requests with no addresses, with addresses that are rental homes, with addresses out of state, all kinds of issues. Our second ask is something that's been talked about quite a bit, and that's the period to comply. What I would say is that if we were receiving, for example, 1 or 2 requests per day, a 10-day time frame to complete that request is absolutely doable. The problem, and what we've seen in New Jersey, is we received tens of thousands of requests over the course of a very, very short period of time. And it was incredibly difficult for us to comply within the 10-day time frame. So those are really 2 separate issues. And that's one, the assignment of claims, and in my view, plaintiffs' attorneys doing everything they can to overwhelm companies so that they can't comply. That's really a separate issue. But I think the simple ask is that if we could extend that compliance period to 30 days, and then secondarily give at least some sort of a grace period where if that company, that data broker is making every reasonable effort to comply, but for whatever reason is unable to because of numerous requests or unstructured requests, or they have to follow up for additional information, the potential for let's call it a cure period or a grace period. The final issue that I'll mention is the private right of action, and this has been talked about quite a bit. In our view, what we've experienced in New Jersey, and it's been talked about, is we had a change to the law. Private right of action was included. We were flooded with, as I mentioned, tens of thousands of individual, many times incorrect, duplicative requests over a very short period of time over a rolling basis. Us, like many other companies, on day 11, were sued. There has been over 100 lawsuits filed. I believe it's more like 140. These lawsuits are all virtually identical form lawsuits. In my opinion, many of the companies that have been sued did comply with Daniel's Law completely, or made every reasonable effort that they possibly could to comply, and they still got sued. So because of our experience in New Jersey, I mean, we are against, obviously, a private right of action. I'll just say one thing in closing, then happy to answer any questions. Again, we support redaction bills, and we are more than happy if we get reasonable requests that are clear and they come in through a process, through a form. We are more than happy to shield judges and police officers, and we're all for it. We just want it to work, and I think our primary concern would be a scenario where companies are overwhelmed, unable to comply, and as a result, they go offline, right? Or they take a period of time to get, to make sure that they complete redactions. And, when those types of things happen, you're going to see delays, right? Consumers are going to see delays on their refi. They're going to see delays on that home purchase. They might have to pay more because you got to go abstract those records. You got to go into the county. Those are all the things that, we could see happening, right? And that's so again, we're in favor of it, provided it's done in a reasonable way. Thank you all.
Questions for Garrett?
Okay.
Thanks, Mr. Rogers. Representative Herb Olson. Trying to understand, so that, I mean, you're talking about real estate transactions, and trying to understand a bit about the mechanics of that. And you enter into, some sort of agreement or, preliminary agreement, buy and sell a home. And I'm not a real estate lawyer, but I probably appreciate that there's probably a process where the purchaser in particular, consents to the exchange of various information. And I don't know whether that includes the kind of information that is available for a real estate data broker. But if the purchaser did consent to that, I'm wondering whether some of the provisions of this proposed legislation would exempt that type of disclosure from interfering with the property transaction. But maybe I'm misunderstanding the mechanics of your business.
No, it's a very good question. I think there's a few. So I think issue one would be the consent would likely be provided to the title insurance company, but that would have to extend all the way back to, for example, a third-party data provider, right? Who's actually the one who has the data. So that's issue one. Issue two is in a purchase transaction, when we have a client who is purchasing a home, the examination of title is not actually the person who's buying the home. The examination is on the seller, right? So we would have to hypothetically get the consent from the seller because that's the title at issue. We're confirming that the seller of the property, and we're confirming it on behalf of the buyer. They own the property. There's no tax liens, spousal liens. We're getting all those liens paid off. all it gets very complicated, right? And I think it's been mentioned before. I mean, it's not necessarily that we First American, there's other third parties that are involved in that process and providing that data, if that makes sense.
I may not understand the mechanics correctly, but if, let's say it's the seller, right? And they need to provide information in order to disclose, or in order to assure the purchaser that it's good title and everything. In that kind of transaction, wouldn't the seller be agreeing in some way to the disclosure of that information, even if it's from a data broker?
Yeah, they would certainly be incentivized to. I just mechanically, that may be difficult. And again, we're not advocating necessarily for writing in wholesale exemptions. My primary concern is just making this workable for data brokers so that they will continue to operate in Vermont and help us on transactions.
Okay.
And I think you raised probably a separate issue, and that is if that information is not available from the data broker, there may be delays for that judge or police officer because that information may have to be abstracted at the county level, right? I'm not highlighting that issue because I think some of the items I've mentioned are bigger issues, but that's certainly something the committee may consider is, what the impact on that judge getting a refinance or attempting to sell or sell their home. If that information is not at the data broker level, it would have to be abstracted at the county level, which will cause delays.
Garrett, thank you. So during my opening for presenting the bill, I mentioned the Wired article from November. The future of online privacy hinges on thousands of New Jersey cops. And in there, it talks about First American and DataTree, which on the website says it's the largest database of 7 billion records. And so I'm like, presumably there's Vermont judges and police and everybody who are like covered people that we're trying to protect in this. And I'm just curious, like from your perspective, does it seem reasonable that those people with like heightened kind of, security concerns would want to be removed? And especially like, I know in the article you can go on for a couple bucks and like sign up and like do a search. So it is like, although it is behind a process you have to take a step to do, unlike just like a Google search, it's still like, it's pretty easy to do it. So I'm just like curious if you could help just kind of like, from your standpoint, is it reasonable for those people to want to be removed? And when we say removed, again, not deletion, but like marked private, like that kind of thing. Yeah.
Yeah, absolutely. It's reasonable. And again, we are more than happy to quote, remove all of those records from our platforms and not make that information available. Our issue with Daniel's Law in New Jersey was not accomplishing the result. It's the way it was done. It was tens of thousands of rolling requests over a very short period of time and then immediately getting sued. And in our opinion, we complied and did it. So look, I mean, it's for us, it's not an issue of we absolutely agree that those records should be restricted. It's just for us, it's just a matter of making it so it's doable and workable.
Cool. Thanks, Garrett. That's helpful. And I guess so in the article, there was reference to Peter Andreev, a cop that like his information fully wasn't removed. But like, as you said, it could like from my listening to your testimony, maybe that was like not enough information or something like that. But I am like in the cases where there is enough information and still people are not removed from the database or, marked as private, then without something like the private right of action that we've talked about a bit today, what in your mind can hold companies accountable for the fact that that information isn't necessarily removed when it's requested, even if it's like over and over again?
Yeah, I think I know in other states, the Attorney General has the ability to enforce, these types of things. I think if this committee is adamant on a private right of action, my other recommendations are things like safe harbors, good faith compliance, a higher standard, where the examples you've mentioned are egregious scenarios, right? Where folks are just simply ignoring requests, and absolutely, we recognize that there are likely bad actors out there. But if the committee could consider, making a much higher threshold, because in New Jersey, the threshold is after 10 days, you get sued. That's what happened. So if there's safe harbors or good faith efforts to comply, those are the types of things that I think the committee could consider. Other enforcement mechanisms.
That's helpful. Could you, so I'm just interested, like we would like to make sure that we are like taking steps to make sure it is not frivolous. Could you just help with like ideas for the safe harbor, whether it's right now or offline, safe harbor and the good faith compliance piece?
Yeah, absolutely. Let me take some more time to think about that.
Okay.
And give you a more thoughtful response.
Okay, thank you.
Garrett, is it possible when someone has asked for their information to be privatized, then they want to purchase they want to purchase property, the title search is going on, all of that, and the things that you need access to, wouldn't it be possible for them to sign a legal document that then you can provide to your data broker where you're getting your information from, that would authorize them to give you the information?
Yeah, I think that's a potential solution. Yes, if done the right way, that could be helpful.
Okay. And then, yeah, is it on this same?
It's on your point.
Okay, go ahead. Change a little bit.
I was thinking about the credit freezes for TransUnion and Experian. That when I guess I'll use myself as an example, when I went to go purchase a home, I was on credit freeze.
Yeah.
You just write in, tell them you want to take off, they go do what they need to do, and then it's like time limited, and then it comes back on immediately.
Do the exact same thing.
Yeah.
Did somebody else have another on this? No. My other question is, my understanding that the federal government has similar or has a law for federal judges, and that there's a PRA in that also. And so how are you able to negotiate around that? And how is that different from what we're doing here?
Yeah, we were involved in that, and it was not me in particular, but if I recall, we had some similar requests in that legislation. And that was primarily that request is clear, name plus primary, secondary address, so that we can be sure we're identifying the correct record.
Yep.
And I think that was our primary ask when that happened.
Okay, but I understand too that the federal government has a private right of action as well.
I believe, I'm not certain of that, so I wouldn't want to talk to that.
Okay. Thank you. That was helpful. Thank you.
Absolutely.
Other questions for Garrett? Garrett, thank you very much.
Thank you all. Appreciate the time.
Chris?
Good afternoon, Mr. Chairman, committee members. It's been a few minutes since I've sat in the witness chair. When I started this week preparing for crossover, I did not think that I would be dealing with this bill, but damn it, here I am. I want to. Relatable content. Exactly. And, yeah. I want to start by saying that there is no question we support the intent language in the bill. It's absolutely needed. I think we hear many stories out there across the country about where we are today with society and people who feel the need to take drastic action and go after elected officials. I guess I've been around too long when some of these bills, when I start to have personal stories around some of the bills that the legislature considers, and this would be one. Not in a horrific context, but my wife is a justice of the peace. And she and I had a conversation about the safety of election officials in November. And then we got talking about, well, everybody in town knows where we live. It's just interesting how sometimes these things come home. So that's why I say, without question, we support the intent. As I've listened to the testimony over the last few days, what concerns me is, are we dealing with a Daniels Law bill? Are we dealing with a data broker discussion? Are we dealing with a privacy discussion? They're all incredibly important and need to be addressed. I think about, and I have to confess, this is only with maybe 24 hours worth of looking and research. I have to think about other possible statutes out there in other states, or the federal law, which I've skimmed, not in detail, and question why we're not looking at those as opportunities versus this bill, which goes down a different path, including the third-party entity. That's where I begin to get squeamish on this issue. Our folks would wholeheartedly support an appropriately crafted Daniels Law. And I think the feds have a model for you to look at. The thing in the Fed bill, which, Mr. Chairman, you may get a chuckle out of this because we've had conversations about land records in Vermont. The federal bill, I think, includes state and local government, which I'm not sure how that would go over in Vermont, quite honestly. And it certainly would be challenging for digitizing of land records. I also thought, as I was sitting here this morning listening, I live in Lamoille County. There is a company in Barrie that publishes a little Lamoille County phone book with names, addresses, and phone numbers. I guess they're a data broker. The challenge that I think we have with this discussion here, and I don't think this is the appropriate bill to relitigate it, you have a data broker bill, is the extent of the data broker definition. I think that's problematic. So when I look at this, I'm thinking it's not the right language. In particular, I look at the disclosure definition or disclosed definition. I am happy to stand corrected, but it seems like a number of comments have centered on online information, online data that's published. And if that's the case, then why aren't we specifically targeting that? This bill targets how we transfer information, how we lend information. So when I think about that broad disclosure definition, that's where, damn it, I've got to sit in the chair and say, that's problematic. Representative, to your point on the credit reports, I remember when we did that bill, and it made a lot of sense because you were dealing with 3 credit reporting agencies. Here, you may not know who you're dealing with to turn that switch on and off, especially in, for example, a real estate transaction, because it's not only the title community that we rely on to get good title. That's usually at the very end of the transaction before you close. But we rely on credit reporting agencies. You as a buyer may want a home inspection. I would bet there are a lot of inspectors that have a lot of information on personal customers. It is not publicly out there, but they need to provide that information to buyer, seller, to lenders involved. There's a lot of people involved with transactions. So I believe and I hope that it is not your intent for unintended consequences when it comes to the conduct of commerce in the state of Vermont. This impacts commerce in the state of Vermont. I'm sorry, I've heard witnesses say not the case. I disagree. And I don't think you need to go there. I think where you perhaps could go is, again, look at those targeted Daniels laws that are going to provide the protections that are necessary for these civil servants who do a tremendous job, but in today's society and sometimes are in harm's way. And that's what I would ask this committee to do. 342 is not ready for that at this point. How you get there, I don't know. You folks have done monumental work this week in crossover. I've seen the number of bills you voted out. This is a challenging topic to try and get out in the next 24 hours, quite honestly. However, it's one that I think you ought to keep discussing. There's always ways to attach to other vehicles that are passing through this body. But I would respectfully ask that perhaps you take a step back from the language that you have in front of you and look at what some of those other states done that are not as problematic as the changes that occurred in New Jersey. Look at what the feds have done and say, okay, maybe that's a different approach that we can get our arms around. This, for us, is not that approach because of the way it's structured in the bill. But the intent, absolutely. I haven't met anybody who disagrees with the intent language that you've got in here. I told Monique I'd go for 45 minutes.
Cute.
So
Start singing.
No,
no, not at all. Happy to answer any questions.
Yeah, so getting back to this, so those particular transactions, we all want to make sure that continue on.
Right.
Getting back to that subdivision 7 at the end of the bill. And I'm trying to think why that wouldn't cover, maybe you might need to refine what you mean by express authorization, the particular kinds of, what kinds of transactions, including not be limited to, this, that, and the other. Why wouldn't a major transaction where you need a credit report, you need title, you need other things? Why wouldn't just a normal practice, if it isn't already, why wouldn't a normal practice be to get the party's authorization to the disclosure of that information?
Who's the authorization going to?
I would assume, I assume, so for example, if a bank is looking for information in order to approve, a loan of some sort.
But understand, we're only one party to a transaction. Is it now the financial institution's responsibility to convey that authority? So no, I know you're not. I'm just offering it as an example of the mechanics that become problematic with that section, because you have multiple players that are involved. And to me, it's the responsibility of the individual who's sought that protection, if you will, that the records aren't disclosed, to give that consent that they should be. But where does that consent go when you've got multiple parties involved in commerce in a transaction?
Yeah.
So it gets down to the mechanics of how does that function?
I'll need to think about it.
Right. But again, I'm not sure you need to even go there if you look at, if you either address the definition of disclosure or you step back and look at how it's structured in the other true Daniels laws to see if it's addressed in a different way. I respect what you're saying. I think for us, it's just the mechanics of how you make that work.
Good. Other questions, Chris? Michael?
Yes, sir.
How would you feel about it if it?
No crypto kiosks in banks.
I actually made a deal out. No. How would you feel if it were the 10, you get the notice, 10 days, it only applies to direct consumers, because at the end of the day, business to business transactions, I think, are a little bit different.
Yes.
But direct to consumers is a completely different conversation going on the internet and getting that information. Why do I individually need that? I'm sure there's a reason, but that being said, it applied to direct to consumers. And the 10 days is the standard, but if the entity cannot fulfill that standard, they have to reply with an explanation of why they cannot do that. And how would it also make it more palatable if we remove the private right to action and it would be a report to, would it be the Attorney General who
Right.
would take care of that?
Right. So I just want to clarify, when you say direct to consumer, so it's not a third party, it's the consumer that's going directly to the entity. Okay. So I think that gets back to the previous witness's experience of if you're getting one or two of those a day, that's probably pretty easy to deal with. It's when you've got it batched and you're dealing with hundreds or thousands, that's when you run into the difficulty of not being able to accomplish it in 10 days. And I would agree with him that there's probably a lot of John Smiths in the world, or whatever. And to have that additional identifying information is important because, and I'll give you an example. In our world, the way we do that is with the social security number because it's a unique identifier. So that I know I'm dealing with Michael Booten and not somebody else, because there could be 100 others out there. So I think that direct to consumer can make sense. I think it limits that batching that could be problematic out there. So I think the 10 days becomes a little bit more workable. Your concept about if I can't do it in 10 days for whatever reasons, I correspond with you and let you know that. There probably has to be some time frame at the end that you have to kind of cut it off. And then I think about private right of action. I fall in two camps. The one camp is we've had class action lawsuits, private rights of action against on ATMs and technology in ATMs, and we've also had it on websites regarding the ADA compliance. And oftentimes our banks write a check because it's a reputational risk and cost to go to court, even though they feel they have not violated anything. We've had private right of action in the statutes for years in Vermont. I get that. I'm one, having listened to the Attorney General testify the other day in Senate institutions. I've thought about it, and I think I've shared it with one individual in this committee. If the Attorney General needs more staff in her shop to deal with privacy issues, give her more staff. And then you don't need a private right of action. I would have no problem with that. I use as an example, correct me if I'm wrong, Mr. Chairman, didn't they bring somebody on board for the home improvement fraud at the Attorney General's office? And that person in 1 year has brought in $800,000 and dealt with a number. Great. Let's create that capacity of folks who have the expertise to assist consumers in the market. So that's another alternative.
pause. I forget that we had another
Sure.
presenter and they have a hard stop at 3:30.
Yeah.
So if you're not going anywhere.
Ever.
Okay.
Camping out.
Okay.
Hey.
We got captive insurance, now we get captive.
Yeah.
Lauren, good afternoon. Thank you for joining us.
Oh, hi there. Thank you so much, Chair, Vice Chair, the whole committee. Thanks for taking the time for bring me on board. For the record, my name is Lauren Schultz. I'm the McConaughey and Rissman Professor at Florida State University. I'm a privacy expert. I've been teaching here for 7 years. Before that, I was a postdoctoral fellow at Harvard for their private law program and at Yale for their Information Society program, which is kind of a law and tech center. I've written a bunch of articles about privacy and also about contracts and commercial law. So I'm a contracts and commercial law expert by trade, and a particular interest of mine is actually privacy. So I decided to come on board. I've actually written a paper that was published in William and Mary's Law Review about private rights of action in privacy law. So I was invited to come here just to answer some questions and talk a little bit about that topic in general.
Thank you for taking the time to join us.
Yeah, thank you, Lauren. So so just so everybody knows, I've been trying to get a hold of Lauren for like a year. We had a call this morning and she's on break. And so I was like, can you please jump on? So she had no time to come up with testimony at all. This was thrown at her. So I'm going to just run through a few questions if it's cool to frame up things, Lauren. So and your paper was posted to the committee website as well. So it's there for people. First, I was just wondering if you could speak to, in your paper, you kind of highlight how private and public enforcement are complements to each other, rather than substitutes for each other, and having one or the other. And really, in a good law, we want both.
So really, this is kind of a concept borrowed from engineering and computer science to sort of help us understand what makes for effective regulation. So oftentimes when we're thinking about systems, not systems of government per se, but just computer systems or machines, we are looking for resilience. That is to say, we want the machine to continue to work even when unexpected things happen, even when there is some type of source of stress. So sometimes to make machines resilient in all types of environment under unpredictable sources of stress and the like, sometimes we don't choose the most efficient way of building the machine or having it do its work. We choose productive forms of redundancy. So if, let's say, something gets clogged in a particular tube, we don't have to put the machine in the shop for 3 weeks and not produce anything. There's another tube, which is technically redundant, to allow the machine to continue to work. And in the meanwhile, we might be able to fix the problem, right, to make the systems resilient. And we actually see, and this is sort of a established concept in a little bit of talking about law and regulation, that often we see multiple pieces of legislation targeted at the same problem. And sometimes we see multiple avenues of enforcement targeted at the same problem, not because it is efficient, but if we value a particular principle, or if we are particularly concerned about averting a certain type of harm, it is often it can be a wise regulatory choice to offer multiple avenues of enforcement. So in the case that one avenue isn't working very well, the other will be there, and we might be alerted of the problem via the fact that there's so much bottleneck in one avenue as opposed to the other. I can say more about this, but that's just an introduction of the concept that I advocate for in this particular context, and that other scholars have talked about in other contexts outside of privacy.
Thank you. And so I guess continuing on that vein, When we're looking at like pure AG enforcement, the AG does not represent the individual person. So if they have an issue, they're not going to like take up that case. They represent the state. So, and so when it comes to individual people, if they have, if they're like David versus Goliath in a situation where they have a harm, they need to sue, but then they could be going up after against a multinational, corporation that has millions, if not billions of dollars to fight a case. And this could be one individual person who is under severe threats in this case for Daniel's Law. And I'm just wondering if you could speak to like how private right of action, but mixed with private industry can actually level the playing field for people to be able to seek redress for harms and
So
threats.
when we're talking about things that are either really core to someone's identity or really core to their ability to lead a life, often we see on the federal level the award of private rights of action in addition to regulatory enforcement. So, for example, with Fair Debt Collection Practices, the Fair Debt Collection Practices Act not only allows the FTC to come after debt collectors who are engaged in unfair debt collection practices, but it also allows the individual the right, because a debt collector could really be impinging upon someone's privacy by engaging in sort of unlawful practices like giving them a bunch of calls in the middle of the night or making statements about how they owe money at their work. Let's say that might actually hurt their ability to stay employed and things like that. When you are beset by something, even when the odds are low, it's good. Often the law federally sees fit to accord private individuals the right to do something, even when the state is unwilling or unable to help, because the state is subject to limited resources. And what's more, as a result of the limited resources, they often like to choose, the cases that will make the biggest statement in general, or the cases that are the most egregious. But what happens if something is really affecting you personally, your ability to get by in your day, your ability to your reputation in your community, but the relevant regulator just simply doesn't think it's the worst thing in the world, or it isn't a signaling case. And that's putting aside the possibility that the relevant agency is captured or just substantively disagrees that you actually have a case, even if you do have a case. So what I think is helpful about the redundancy is if you see a lot of individual actions coming forward of a particular type against a particular actor, that might kind of shame the public actor into acting, right? And you might even actually end up getting a little bit of push on that point, even from industry, right? Because it's actually a lot easier to deal with a one centralized place than many different claimants. And there's a lot of in a lot of regimes, and I can give you a bunch of examples. There are different ways that the law deals with allowing public and private actors to collaborate and to not actually be a direct double hit, right? But the thought is sometimes the public is able to act when the private actor can't, because let's say the private actor is too small and unsophisticated to conceptualize the wrong, much less seek redress. And on the other hand, the public actor isn't perfect either. The public actor doesn't necessarily have the resources to go after everything. And when the violation of right is very personal, that is to say, like if we're talking about these Daniel's Law cases, threats to your own family, it seems there's something perverse about having the question of whether or not anything can be done at all come down to whether or not a third party thinks it's appropriate for the public interest. So I think that both both can support one another, and I can't say that it is efficient, but it often is the most effective and resilient against a collective harm if we think the harm presented by the fact patterns that cause us to pursue these laws, if we think it's important enough, it's important to make sure the law can respond, either public or through a public avenue, a private avenue, or both if necessary.
Thank you. And then you did deep dives on, I'm going to read these off because I won't remember what the acronyms are. The Telephone Consumer Protection Act, so the Do Not Call list, the Fair Credit Reporting Act, and the Driver Privacy Protection Act. But then you also, and so part of that, you referenced the Brim versus Midland credit management in saying that FCRA is the primary factor in deterring erroneous reporting by the credit reporting industry. But then you also, there's a whole section that you went into on non-consensual pornography laws and about how that is how that has more of those have included private rights of action in order to like shape business practices. I'm just wondering if you can like talk to some of those specific things that you've seen actually shape good business practices and kind of like the benefit of the private right of action to get us there, like social change wise and business innovation.
Sure, right. I think that having the actual threat of lawsuits is a really good deterrent for bad behavior, right? And there's no better deterrent than knowing that not just it's not a question of convincing one actor not to move. It's a question of not necessarily convincing everyone not to move, because of course there's always going to be lawsuits, frivolous lawsuits, right? But if there's a private right of action, you definitely have to make sure your policies are good enough so that the lawsuits will actually be frivolous as opposed to non-frivolous, right? And while it is expensive dealing with frivolous lawsuits, ultimately they do go away. And my belief, frankly, is as we are moving more and more towards making use of big data in a lot of different parts of governance, we're going to see frivolous lawsuits being handled more and more affordably, for better or for worse. So I just don't really find the fact that some lawsuits might be frivolous persuasive enough, given that the threat of lawsuits that can't immediately be dismissed is really the best possible deterrent. So to speak more specifically about the TCPA, among other things, makes certain forms of calling to advertise or to pitch things to customers unlawful or tortious under certain circumstances, right? So there's a do not call list, but additionally, it's there are some policies like, okay, well, if you request information from someone, it's okay for them to call you for 2 years, et cetera, right? So if you follow those parameters, then you will not have any problems. So this is an example of, okay, there's a good safe harbor. Nonetheless, if you're not careful, you can call people within those categories. And there's a whole cottage industry of individuals who, have a bunch of phones and they keep track. And if a company runs afoul of the TCPA, they could be hit with and have to sell a lawsuit if this person, who is a litigation entrepreneur in most cases, is actually, so this actually, by making it expensive potentially to act in a way that's contrary to the rules, it actually provides a stronger deterrent. And you also mentioned non-consensual pornography. So non-consensual pornography is a crime in many states. So it's against the criminal law. But there are also circumstances, and this is quite limited because we have a safe harbors for just it being on the website, right? But this is sort of for people who knowingly distribute. Turns out that this does cover enough cases by having it be tortious as well, it does cover enough cases that it encourages a lot more self-policing by entities. So we see the increasing marginalization of revenge pornography. Like you can unfortunately find it on knowingly hosting websites of it. But most mainstream social media sites and even sites that carry homemade pornography, if there's the slightest whiff of it, they end up taking it down, not because probably any hoster of it is probably not going to be able to be liable under any criminal or tort statute, but the fact that the threat, I mean, it's kind of you might say it's an expensive and inefficient way of creating a deterrent to certain types of behavior. But if it is important for legislators or from a policy perspective to prevent a certain type of harm, we don't want to have the only avenue for relief be in the hands of just a handful of government officials without any external pressure and guidance from what's popping up in the courts. So I think that the external pressure, the additional incentive, provides information and provides additional public pressure to public entities doing their job. So this is, I don't think of it as a replacement, although in certain areas, like for just to hop on my soapbox since I'm talking right now anyway, private rights of action appear in a whole lot of different areas. So not just outside of private privacy, we see the Securities Exchange Act, right? The SEC is the primary public enforcer, but also private investors can sue for security fraud, right? Because if we think something needs to be averted, if you're an investor and you're being potentially defrauded or something by the people running the company, it's kind of not good enough if the government says, well, hey, I don't think this is a big enough deal, so I'll just let them live. It's a personal interest of yours. Your money's basically being taken from you. And similarly, when we're talking about the Fair Housing Act, the Americans with Disabilities Act, these are sort of important interests against being personally discriminated against. So on the one hand, we have a situation where there's the overall public good that's being served, which is why the public is engaged in enforcement. But often the law decides that, hey, this is an important enough interest to the individuals affected that if the public actor does not choose to act, we need to have an additional incentive to get the public actor going, to shame them into moving, but also just to give the affected person any recourse, right? Because I'm not going to lie, I think for the average non-litigation entrepreneur, the better way of having their interests validated is going to be via a public avenue rather than a private avenue. But giving them some opportunity to put some pressure on some public actor to vindicate a very important interest, like in this case, the safety of a family, but similarly, interest against not being discriminated against, or an interest in not having something you invested with be stolen from you. It's kind of cold comfort just to say, oh, the government will take care of it. You don't even have the right to make any attempt to protect your own an interest that's substantively important to you personally, in addition to being something that is important to the public generally.
And last, so your paper opened up with the story of Florida trying to pass a privacy law with a private right of action, which very closely echoed everything that happened in Vermont. And in general, the lobbying and influence on privacy bills in state houses and federally is massive, and this bill is no different than that. And so I'm just curious if you could illuminate why everyone is so determined to defeat PRAs.
I think
or not even talk about them.
Well, I think, I mean, I would like to, of course, advise all of you to consider this in this case, because in terms of a Daniels Law, I think one of the biggest concerns with private rights of action, their weakness in terms of being passed is their strength. People are concerned that they are too strong, right? The reason why industry doesn't want them is simply because it creates too much of an incentive for a public actor to act. Like a flood of litigation, I mean, that is rhetorically a very powerful statement, but in the age of chat GPT, it's not that difficult to create documents and have documents read and responded to. I think the bigger concern beyond demonizing lawyers is that if you have a private right of action, that's going to put a battery in the back of public regulators to actually make an effort to make rights that people agree are important effective, because if they don't do anything, private actors will act. So it's either a reasonable public actor, or regulation will be left to entrepreneurial plaintiffs litigators. So it encourages some type of action. It encourages thinking about what a safe harbor looks like. It encourages actual movement. Whereas when we don't have a private right of action, it's easy to say, all of us agree that this right is important. Let's just say it exists. And if the public actor doesn't have the time or the money to address every single instance, well, so be it. I mean, that would be convenient, right? Whereas with a private right of action, something happens. I will say that one thing that I advised in the paper as a potential loophole is, first of all, I would say, like, I think safe harbors are a good idea. I think sort of toggling the limitations are something we can do. Although, again, because the problem is accountability, somehow no safe harbor is safe enough. Somehow no amount of limiting is something that's good enough for some actors. But I think that this one is kind of special because it reminds me of the VPPA, which is a federal law still on the books, which protects the Video Privacy Protection Act. This protects the wrongful disclosure of videotape rentals or sales records. And so the privacy interest in a person's ability of people to know what someone's consuming in terms of videos rented. And I think that this made it through, and again, it was a long time ago, and it did flow from the embarrassment of someone who was going to be a Supreme Court justice, and really the videos he was looking at were not that bad. They were just normal films, and people thought he should be watching, I don't know, Hamlet or something, documentaries, and instead he was watching like Mel Gibson movies. But enough with that. I do think if it's really, really narrow, it's kind of hard to take seriously that, okay, is any business going to be shut down entirely just by people who are trying to protect themselves by being attacked? And it just sort of strains credulity that a law this narrow could really lead to a parade of horribles that could have bad impacts on industry as a whole. Whereas if you're talking about a general privacy law, those arguments become relatively more persuasive. But I think I'll end with that. I think that people are afraid of them because they're effective. And ultimately, there's fear of real accountability. And it's easy and good to make a general statement of a right, but without a remedy, rights aren't real. And private rights of action tend to pressure public actors, who will normally be the primary enforcers, let's be real, to act. And I think that this is a narrow enough law that a private right of action, I do think it strains credulity to see whose business operations have shut down in response to just allowing public actors. I mean, the whole cost-benefit analysis. Should some additional motion practice for a handful of firms acting sloppily be allowed to make legislation that protects the lives of the children of public servants not go through? And again, obviously, there's a lot going on here, and who am I to judge anyone? But I think that it's really important to protect the home life and safety of civil servants. And if we consider something to be really important, having multiple avenues of enforcement is appropriate and very widespread at the federal level and at the state level here in Florida. I can't speak for Vermont. So unfortunately, I have something of a hard stop. I really appreciated having the opportunity to speak with you, and thank you so much for all of your service and work, all of you guys there.
Thank you.
Thank you, Laura, for joining us.
Thank you.
Absolutely. Bye-bye.
Bye-bye. Chris? I think there were a couple of questions that people had.
I got some laryngitis up the last few minutes. Yes, sir.
Can you be very specific on the impact on business to business transactions due to this? Is that, okay. Oh, I thought you were gonna, I thought he was running away. I'm like,
Sorry. Let me check. This is probably- Glasses. So, if you don't mind, page 4.
Okay.
Parentheses 5 on line 8. Okay.
Okay.
So consider how that paragraph reads. So again, listening to the comments of online postings, public facing information or data. This talks about means to solicit, sell, manufacture, give, provide, lend, trade, mail, deliver, transfer. Okay. Publish, distribute, etc. So when I think of, I need to get a credit report when I establish a relationship with a financial institution when I'm going for a loan. Bank needs to get a credit report. If this impacts that ability to transfer the information from the credit bureau to the financial institution so they can do their due diligence, that's a problem. If you have a situation where you've got a financial institution that is very active, which all are, in fraud prevention, there are providers out there that we would work with, but if this disclosure piece limits the ability to provide that the transfer of that information back and forth, that's a problem. Again, you heard from the title community. So to me, those are some examples in our world. We deal with a lot of different entities out there in order to provide service to our customers. And that free flow of information, which I would argue is not published for the public to look at, is not out there in an online environment that is searchable, is very critical for us to work with our customers. So to the Representative Olson's point, in 7, does that solve it? To me, 7 has to be directed between the individual and those entities. The concern I would have is if you're saying you as the individual have the right to tell XYZ company the disclosure is off, if you will, you go ahead and I'm not sure we want to take on that responsibility. So that's where I think it becomes problematic when you're talking about this type of an approach in that definition.
may I continue? I appreciate you making that comment because one of the things that I'm a little concerned about is possible anti-selection and fraud as well. Which anti-selection will be. So you see that could have an impact where somebody could, do that non-disclosure and then go to a company that they think would ordinarily get that and benefit from that non-disclosure.
I don't see this as simple as your example of the credit bureaus. That's the mechanics that I'm struggling with. The credit bureaus, I know where to go. I can make that call. I can lift the credit freeze. I can go down the road, buy the car, and then I can have the credit freeze apply. There's multiple entities that I think would fall under the definition of data broker that have a positive daily impact on our lives. That mechanically, I don't know how that works. And that's why this definition to me is problematic versus the direct statement of my information. If I was one of these protected individuals, I don't want my information published online. I don't want to be in the white pages online. To me is very clear.
It's that business to business transaction that
Yes.
really becomes a huge problem as someone that's dealt in that realm before, it has a huge impact on every single part of our life.
And I think for years as I've been doing this, I'm well aware of good actors and bad actors.
Right.
And sometimes it's difficult to craft the right policy that targets those bad actors and incorporates all of them and avoids the unintended consequences of those good actors in the marketplace being able to continue what they do. That's a challenge for policymakers.
Yeah, I guess on some same subject, I'm thinking about the mechanics of it too.
Yeah.
I'm wondering at the point of request, because my assumption is that in the case of purchasing a home, the bank will have to go to a third party to pull that information. So they'll have to call and make the request, right?
You are signing an authorization form that allows me to go to the credit reporting agency and get your credit report.
I'm not using that specific example, but yeah.
But yeah,
Right.
but we're doing that today in an environment where you haven't blocked that information.
Right, but if there was a mechanism that says I've lifted the block, you now have permission to proceed and go forward,
Yep.
would that
Would that
help?
be more palatable?
Would it help alleviate? And I'm also wondering, I'm thinking about like, for instance, if I am composing a mailing list.
Yeah.
And I'm putting it through a MailChimp or some sort of third party app.
Right.
If I pulled those in person and it's coming off the list, at the end of when I put in the information, they're going to be like, did somebody give you permission to do that?
Right.
And I have to click yes or no, which puts the burden of responsibility on me.
Right.
So could we maybe I understand that
Yep.
complex transactions is what, but I mean, you have to data entry something. Can you just click something and say, hey?
Is it possible? I would have to say probably.
Okay.
But for me, before I even get to that point, I think I would want to know from a policy perspective from you or the committee, is that really where you want to go based on the disclosure definition? Or are we focusing on that online presence that people have talked about as the concern? I don't know which direction you want to go in. If it's the direction that you're talking about, then we've got quite a bit more work to do to address that definition and how you deal with the mechanics. If it's the online piece, then you've got more work to do to narrow it to deal with the online piece. That's your policy choice. I just don't know which way you want to go yet.
So I'm struggling with what I don't know. And I think you're alluding to things, but not saying them directly. And so I really want to understand what that is. Like when you said fraud prevention.
Yeah.
Make a purchase.
Yeah.
Credit card company reaches out, text, phone, whatever, say, is this you? How does it, like, I don't see how that, where's the friction? Where does this impact that, right? What are the pieces that I'm missing that are not visible to me?
So some of my banks issue credit cards, so we would be the one that's interacting with you, that's business to business. But then there's third-party fraud prevention companies that we would work with that are obligated to follow our rules, if you will, that provide that service for us. That may not have a direct contact to you. They have the contact to us as the institution. So that's where the relationship rests, is with us and that fraud entity. So if you have blocked your information under that definition, My concern is how do we continue to work to successfully prevent fraud for you?
What I've blocked is my name, no, my home address, my primary phone number. Right? Like that's what I've blocked for my, so,
Correct, but that's,
and we have
I'm
the,
sorry.
I'm really struggling with this. We have the, if it's for the purpose of facilitating a transaction initiated by the covered person. So as when I sign that credit card.
Yeah.
I have a credit card with you.
Yeah.
You're telling me what you're gonna do to protect me.
Yep.
In that process. So I've signed something that says that we're in agreement that you can support this relationship, right? This business relationship. So I'm really struggling with.
Okay.
how-
So
It's gonna be.
but again, that's the relationship that you and I have, right? You're my customer. So you have given me the consent to go ahead and perform that function for you, if you will.
Yep.
I am using that to work with my third-party provider. Okay? My third-party provider, you have to keep in mind that customer data. So I know Edie Granning, I know Edie's phone number, I know Edie's address. I'm probably going to get your account information as well, is important. So I have the right Edie Granning, number one, so that I can make sure you're getting the service. But you've blocked that. You have now, in this bill, as I look at this, you have blocked that. So now how do I, as an institution, get that information to provide the service? Because that entity, if they are the data broker, which they would be, in this bill, under 4 definition, it becomes problematic to share that information because you have blocked it.
Yeah, I guess I'm struggling with the fact that I can, it would make sense to me. I would hope that the business that I signed the agreement with was very clear with me and said, you're signing an agreement with me that says anything that I need to do to provide this service is covered, which would cover you and the third party, right? And if you're not doing that, that's really not a good business practice. Because
So are you
have
going
to be able to provide that service?
So I would hope that you would write that into the bill because right now we can do that because your information is not blocked with a data broker. This bill blocks that information with a data broker. You're changing, to me, you're changing the business environment and how you want your information protected and what the data broker needs to comply. So if you want to go to the fraud provider that we're using and say, I give you permission to release this information to the financial institution, that's fine. It works today for the very reasons you described, because we have that relationship and you have given me the ability to work with that fraud company. But the data is available through that fraud company. Here, it stops that from happening.
Yeah, I'm thinking that it doesn't because of the very end of the bill. There are certain times where the disclosure of protected information is not a violation. And I think that what we're talking about is not a violation. So we can confirm with legislative counsel. But
Sure. Sure. I have a different opinion, so let's get the lawyer in the room and figure it out. Right.
thank you.
Let me talk to him first, but
I appreciate you going to. Thank you.
Yeah.
Did you?
I was gonna go down that rabbit hole, but we'll just wait for the attorney.
Can I talk a little bit about, because the previous witness talk, she offered, I think, a good framework for when a private right of action is and is not appropriate. And she was, talking about agencies that regulate, different companies. And of course, they have that capacity to regulate.
like our friends at DFR. Yep, as an example.
Or the AG or whatever. Sure. And she was talking about in terms of the kind of the tension between frivolous and being able to enforce. Are you familiar? Well, two things. One is that kind of regulatory regime? Yeah, do you think that kind of regulatory regime might be appropriate for this kind of business? Or if it's not, if they don't have the capacity, are you familiar with anything that allows, say, a regulator to somehow gatekeep or be able to review complaints under the statute
Right.
to make sure, number one, they're not frivolous, and number two, that they're consistent with a statewide policy that you want to have.
Yeah. I'm not sure I can answer that, but let me try. I think you'd probably find that some of the data brokers that fall under Vermont's definition are already regulated entities. Depends on the service that they're providing. Credit bureaus would be one. I think as an example. You could probably look at the title insurance community as another one that's regulated. And then we could also get into, and I don't know if they'd be data brokers, but they're also, our Office of Professional Regulation in the Secretary of State's office has rules that govern professions out there in the marketplace. That's another type of regulator. So I think we might find, Representative, that there's probably a group of people within that database that are regulated already and theoretically held accountable by the regulators if they're doing things inappropriately against their rules or regs. And then there's others who aren't. And that's just a guess on my part, but I do know some of the folks that we would interact with would be regulators. So, and to your second point of, and I'm going to use my words, are you thinking like a gatekeeping system that looks at, I don't want to say claims, but looks at possible concerns of violation and makes a determination whether those are correct or not, or maybe I'm misunderstanding.
I was thinking actually primarily of the nature of state policy, state regulatory policy.
Yep.
And sometimes the private right of action, unless it doesn't have to be, but there would be concern maybe at the regulator level or maybe at the industry level that you don't have consistent state policy.
Yeah, I mean, it's difficult for me to answer because we are so used to working in a regulated environment with our Department of Financial Regulation, with our other federal regulators, and having to be examined for compliance with those rules and regulations. So for us, we've got those gatekeepers that look at whether we are consistent with state and federal policies. So it's I'm having a difficulty answering your question.
Are you familiar with the Social Security Index?
Familiar with the Social Security death file? Is that what you're talking about? Yes.
Sorry. Is that a third party that pulls that information? I think there is a third party that pulls the information and sends it.
Yeah, I don't know. I'd have to check with my folks who deal with that type of information.
Okay, so if it was a third party that and somebody had requested to them not to disclose information, that means that any type of institution that's pulling upon that would not be able to get that information that's provided, notifying that institution that the person has passed away, correct?
That's how I would interpret the language that you've got in this bill. I could give you a real example. Your tax department hires a third-party data aggregator and it is built around people who have not paid their taxes. They're delinquent in their taxes. They take that data and they go out to financial institutions and ask financial institutions to scrub their records to determine, does this person have an account? And the tax department may make a decision to go ahead and put a claim on that account. That is a third party entity. If I'm looking at this bill and I want my information protected, does that mean that entity can no longer do that work for the tax department until they get my release to go ahead and do that? Again, it kind of gets back to the mechanics of how does this work when you've got multiple players in the market that are doing business to business transactions that are completely behind the scenes. I'm not aware of any of that information that's out there in the public versus your public policy question here. Are we talking about public facing information that's posted on a website, that's aggregated, posted on a website, that's published in my little Memorial County phone book? Is that where you're going? Or are we talking about what you've got here? And if it's here, that's where I see the bigger problems with the business to business commerce that need to somehow be fixed. Because again, we agree with the intent language in the bill. Absolutely. Thank you, Chairman. Committee members.
Thank you, Mr. Chair. I agreed to go last because I assumed there would be afternoon cookies that on Wednesdays. Misled. I'm getting sued at this stage. We have 10 days, all right? We have 10 days. It doesn't take. These if I start to flag. Thank you. Good afternoon. So for the record, my name is Matt Atkinson. I'm here to give you my opinion on data brokers, Daniels Law, H342, and the need to better protect public servants from harassment and violence. It may be helpful for me to address a few points right up front based on testimony I've heard. First, I heard a previous witness claim this morning that privacy statutes like New Jersey's Daniels Law are ineffective and do not increase the safety of at-risk individuals. That is a completely false and dangerous assertion. You can read plenty of material on this from the Secret Service, the U.S. Marshals, the Administrative Office of the Federal Courts, and I have personally witnessed firsthand the benefits of this protection, and I felt the duty to make my position on that absolutely clear. Second, I've heard questions and concerns about data deletion. I think the word deletion is often used as a proxy in this discussion for non-disclosure. That happens a lot. This bill is not about deleting data. It is just about non-disclosure and redaction, period. In fact, companies are not required to delete anything, and they can keep data for any internal purpose they want or need. And indeed, they should maintain internal suppression lists so that they do not inadvertently re-ingest data, protected data, and redisclose it. Third, regarding the example provided earlier of the DPPA and vehicle recalls for faulty vehicles, nothing in this bill would prevent a car manufacturer from sending a recall notice to a vehicle owner. Nothing. If any member has questions about this, grab me and the automotive lobbyist who I met yesterday. Seems like a lovely person, and let's spend a few minutes dispelling that myth. It'll take about 120 seconds. Fourth, a few witnesses have mentioned that New Jersey's Daniels Law was recently amended, and the implication is weaponized to include a private right of action. The PRA has been there since the initial passage of the law in November 2020, 4 months after the murder, almost 5 years ago now. Anyone can look up the bill history themselves, verify this in a minute. Fifth, regarding some of the questions and testimony about business-to-business interactions and authorization of consumers, I know certain members keep coming back to this thematic point. This is a very common sense point, and you can see the plain language at the end of the bill. I think it's 7A. Any disclosure made with the authorization of the individual is permitted. If you log into your bank's website and they want to run a fraud check on you, they can. If you need a background check run, it can be run. And as we heard, legally, it should only ever be run with the permission of the individual. Perhaps that language can be clarified so that it clearly extends to any business involved in the chain of a sequence transaction. But for the purposes there, I would endorse transparency to the point that was made earlier so that the individual understands who is being involved in the data broker ecosystem. Maximum transparency. Those edge cases aside, I worry that most of the objections we've heard seek to distract from the real and highly profitable business model that certain data brokers seek to maintain, disclosing protected information without the permission of the individual, indeed, usually without their knowledge. Lastly, a fundamental point. This bill allows for covered persons to make individual choices for their own lives. This whole process only starts when an individual decides to send a non-disclosure request. If they want to do that, if they want to send a non-disclosure request to a bank or to a fraud prevention company or any other data broker, that is and should be their choice. Okay. As I said, I'm Matt Adkisson. I'm the founder of the Atlas Data Privacy Organization. You heard us described yesterday as wild-eyed plaintiffs' lawyers exploiting a gold mine in New Jersey and now seeking to do the same thing here in Vermont. According to certain data brokers, we are Voldemort, a name to be whispered in the hallways and never spoken out loud. We are controlled by private equity boogeymen from Silicon Valley. We are here to flood your courts with frivolous litigation, sue Vermont Teddy Bear, and probably shut down Ben & Jerry's before we are through. None of this is true, of course. As many of you probably know better than me, if they can't attack the message, they attack the messenger. And that's all this is. That's what they have done and will continue to do because their arguments against this bill and bills like it on the merits fall short. So if what they say about us isn't true, let me tell you what is. First, I am not a lawyer. Probably should be the first thing I say. I am not a lawyer. Prior to founding Atlas, I never sued anyone or participated in any litigation. I have never drawn a salary or made any profit from Atlas. Atlas doesn't even cover my health insurance. I've pledged any of my profit from our litigation to charitable and advocacy organizations working to advance and defend, because they will be attacked even once they're on the books, data privacy and security rights. I dedicate my time to this organization and this cause because I deeply believe in the mission. I'm in a position, a very fortunate position to be able to do that because mostly due to dumb luck and being in the right place at the right time, I enjoyed a very successful 15-year career founding and building cybersecurity companies. When COVID hit, I retired from the private sector, intending to spend the second half of my career in public service, following the example of my parents, grandparents, and pretty much every other member of my family. I thought through what form that service might take, perhaps national security work in DC or a diplomatic assignment overseas. But as the saying goes, we plan, God laughs, and then he sends you to the middle of New Jersey. Some friends and I were exploring California's statewide privacy law, trying to protect law enforcement officers in that state, but failing due to lack of enforcement and a resulting lack of compliance. We had just about thrown in the towel when we heard about the murder of Daniel Anderl and Daniel's Law, more than a year after the law passed. At the invitation of New Jersey's largest law enforcement union, we refocused our efforts there and started building software and services that could help their members at their request. In California, we were working with a small handful of officers, but now in New Jersey, almost overnight, we were responsible for helping more than 50,000 active and retired PBA members and their families. Almost immediately, we started receiving reports and phone calls from officers being doxxed, swatted, harassed, threatened, or targeted with violence. The number of incidents were far greater, far more graphic, far more frequent, and far more devastating than my partners or I could have ever anticipated. I personally spent hundreds of hours meeting with targeted individuals and their families in person. I sat at countless kitchen tables, literal kitchen tables, listening to stories of lives turned upside down. I heard some of the most courageous women I have ever known express guilt and shame, believing themselves to be bad mothers because their public service had put their young children's lives at risk. Not theoretical risk, real risk. I watched some of the toughest looking men in the world break down, feeling helpless to protect their families, feeling like they had to choose between an important job that they loved and did well and their family's safety. Fast forward to the moment when the software platform we were building in New Jersey finally launched. Data brokers started receiving requests from covered persons asking them to cease the disclosure of their home addresses and phone numbers. That's it, just 2 pieces of information. We had high hopes for compliance. We were pretty tired, to be honest with you. We were ready to declare success, call it a day. But almost immediately, we started to receive emails from data brokers stating in writing that they would never comply with Daniels Law. Some even threatened to sue us for having the audacity to help ordinary people assert their privacy rights at all. The CEO of one data broker told me that privacy was a luxury good for the wealthy who could afford to pay for houses in cash and use LLCs or trust structures to hide their identities, not something ordinary people should hope for or expect. In one such email thread where I pleaded for reconsideration and compliance, long before any lawsuit was ever filed, the in-house corporate lawyer for a multi-billion-dollar data broker concluded our exchange by telling me to, quote, cease and desist sending our company these nuisance emails, end quote. She was referring to the takedown notices directly sent by judges, prosecutors, law enforcement officers, and their family members, simply requesting that their home addresses and phone numbers not be disclosed by this company. Nuisance emails, she actually put that in writing. That's how little regard she had for any privacy law. That's how unconcerned she was about any enforcement action or any accountability. Other similar rejections followed, and we soon realized we would have to build out a legal team and seek enforcement in court. The alternative was to go back to tens of thousands of hopeful public servants, including many who I now considered friends, and tell them that we had failed or given up, which I was not willing to do. We now have 7 law firms and several dozen lawyers and support staff working on about 150 cases in federal and state court. Some of the data brokers will smear our legal team as ambulance chasing plaintiffs' lawyers seeking to make a quick buck. In fact, the truth is, or at least should be, much scarier for them. Our legal team, like us, are true believers. They include many former law clerks who personally know and who have personal firsthand experience working with and for prominent state and federal judges, including U.S. Supreme Court justices and Judge Salas herself, whose families were and continue to be brutally targeted as a result of their public service. That's our legal team. One member of the team joined us after a judge he had worked with was murdered at home by a disgruntled litigant. In short, this law, these cases, and the mission they represent are all deeply personal for almost everyone on our side. In the world that some data brokers inhabit, it may be hard for them to imagine anyone doing anything for any reason other than maximizing profit or advancing their own material self-interest. They have a hard time conceiving that anyone anywhere would act out of a genuine desire to help protect others or just do some good in the world. But that desire is what drives us, and I suspect what drives many of you around this table as well. I'll conclude by talking about the importance of effective enforcement and a private right of action, which we heard so eloquently discussed by the previous witness. I think I've met more lobbyists in the last 72 hours than in my entire life up to this point. They all seem like very nice people, and I've appreciated their kindness and hospitality, especially helping me when I get lost in the building. And I acknowledge the important role a lobbyist can and should play, serving as a conduit for interest groups to communicate back and forth with their legislators. But I also think it's worth asking, why are big tech companies and data brokers from out of state flooding the Vermont State House this intensely to defeat a bill that seeks to protect, at most, a few thousand at-risk public servants? Borrowing a phrase from an early American politician, millions for lobbying, but not 1 cent for compliance. What the bad actors really fear, of course, is enforcement. The private right of action in Daniels Law that allows for private enforcement requires data brokers to comply with the law or be held accountable. If you were to pull the PRA from this bill or fill it with loopholes and exemptions, I'm guessing you would see all of this opposition evaporate. That should tell you something. I know from personal experience that many data brokers are run by great executives who want to comply and do comply with privacy laws, but there are also very bad apples. It reminds us, my team, of the opioid market Painkillers were and are an important class of very useful drugs. But then along comes the Sackler family and Purdue Pharma, who, in my opinion, utterly without morals or conscience, focused only on their own bottom line, while millions of Americans suffered and died. Make no mistake about it, I believe history will show that certain data brokers operating today are no different than Purdue in their disregard for human decency and their pursuit of profit at all costs. Following the Sackler playbook, they co-opt sympathetic and often unwitting front groups to carry their message, and they often spend the most money on lobbyists and the most money on advertising to be the loudest voice in the room. Purdue and Big Tobacco before them once seemed so powerful as to be untouchable, but it isn't so. Eventually, these groups are held accountable, and often that process starts in rooms just like this one with ordinary Americans just like us. And by the way, the good actors who run data brokers are some of the most eager to have you crack down on the bad actors, because the bad behavior that the bad actors engage in makes it almost impossible for the good actors to compete without violating the law themselves. In terms of liability, some of the testimony you heard earlier was misleading or just plain false. As I mentioned earlier, you can see the plain language of the bill. At the end of the bill, any disclosure made with the authorization of the individual is permitted, and that's a powerful and appropriate exemption. It's become clear to me that the only Daniels Law many of the data brokers represented here will accept is one that simply is not effective. Lastly, and to conclude, ultimately, I am just a messenger. I don't live in Vermont. Even if this bill passes, which I hope it does, I doubt that I or anyone who works at Atlas or any of our partner law firms will ever step foot in a Vermont courtroom. If there were to be noncompliance, I'm confident that your local attorneys will step up to protect their neighbors, who are judges, prosecutors, and law enforcement officers, or other at-risk public servants. At the end of the day, it's up to you and all of your colleagues. Do you want to protect this group of Vermonters from these threats at this time? If you do, then what I can tell you clearly is this bill is the way to do it. Thank you.
I think some of the consternation that folks are having is regarding the business-to-business issues. If it only addressed the person to business, how would that change your thoughts?
That's a great question. A lot of our view on this issue is informed by active threats that we have worked on for individuals that we represent. America is the land of small businesses, and that's part of what makes us great. Any individual, as many of you know, can go and incorporate and become a business. We have dealt with active threats that have resulted in criminal prosecutions and incarceration, where an individual small business owner uses their EIN in their small business to obtain information which allows them to locate a judge and threaten them with harm. So to us, there is no distinction between an individual or a business, because any individual for $50 can incorporate, get an EIN, and then present themselves as a business.
I mean, I feel like that's not okay. I mean, that almost feels fraudulent in a way, because you don't have any real reason to pull that information. But okay, so the next question that I have for you is regarding the process. And I get back to my comment about public records request, where there's actually, I just double checked it on Vermont. You have to immediately respond, and then you have 3 days, and then you can have up to 10 days unless you have a specific reason that you can't comply within that time frame. The current bill says 10 days. If there was language in there that allowed for that wiggle room, for lack of a better term, how would that impact your opinion on the bill? Did that make sense the way that I explained it? Okay.
It did, yes, thank you. I think not the immediately previous witness, but the Lauren, I think the gal who went right before, gave probably the most eloquent summary of the importance of a private right of action that I've ever heard. And I've been doing this for a few years now. And so I'm very glad that the committee invited her, because that was an absolute joy to listen to. And there were a lot of pearls of wisdom in there. No safe harbor will be safe enough for these folks. The challenge with providing any exemption language, and that's ultimately for you all to decide what to do, of course. But any language you look at or you hear proposed to you, just understand the worst actors in the industry will use it, twist it, contort it in order to avoid compliance and avoid accountability. And so, in our experience, when again we are in court against 150 or so defendants, many data brokers complied, and we know that because we worked with them firsthand as part of that compliance effort. Everything from a solo proprietor, somebody running a very large data broker out of their living room, to large multi-billion-dollar businesses. None of them had any issues or any complaint with 10 business days being an insufficient amount of time. And again, as Lauren said, if the need is great enough, then the accountability has to be commensurate and create the incentives to ensure compliance.
And the final question that I have regarding the private right of action, would it not be better to focus on that after damage is done? And I, as someone that has had issues with individuals, I don't know if our laws are overly efficient at dealing with problems in the aftermath. Should we focus on that? Because even from the previous lady down in Florida, it sounded like if we had more rules and regulations and ability to do something after there's been like an actual perceived damage. That's not really sense. Okay.
I think I understand the question, and I appreciate it. It's something that's talked a lot about. The goal of Daniel's Law is to be preventative in nature. It's not to be compensatory. And $1,000 or any civil action is cold comfort to someone who's had to leave their house because of active threats, or God forbid, someone who loses a family member who's murdered. So really the purpose of the law and the intent of the bill is to be a deterrent, is to be proactive and protective, and to make sure that those tragedies do not occur. And the way to do that is, again, as Lauren, you heard from Lauren, is to create the incentives for businesses to comply.
It's not the businesses that are causing the problem, though. It's the individuals on the end that are causing harassment.
Well, the businesses provide those individuals the home address or the phone number that they use to threaten violence or enact violence or harassment.
Correct. I mean, we can get voter records and have the same outcome as paying $5. I don't know how much it costs to get, Spokio or whatever it's called out there.
On that last point, what some of the federal courts themselves have said is that an incremental approach to privacy is appropriate. Just because there's not an overnight solution to every possible source of disclosure, it is still meaningful and appropriate to prevent as much disclosure as possible. But I agree with you, incrementally, I would endorse working towards a solution that protected as much information as possible across all those channels.
So, thank you, Matt. I have a couple of questions. I hope I can just work through them. The first one sort of pertains to a lot of conversations in other matters and other bills about the choices that individual consumers make, being asked to make a gratuity, things of that nature, and how do we legislate the act of opting in, making a decision. And something that Dr. Schultz talked about was about in that private litigation realm, that tube she was describing. She talks about something that had to do with, these are rights that are, and she's thinking in the testimony she'd submitted, individuals attach greater value to rights if they possess versus interest provided to the sovereign's leisure. And there's a notion of individual to individual dignity that's in that. And looking at something that Atlas talks about, it talks about a fully automated solution to protect law enforcement. Can I hear a little bit about how people where their choices begin and end in engaging with Atlas, are they okaying a series of investigations on their behalf by Atlas? Do they opt into each of them? Or do you become their, in the language of the bill, their authorized agent? Tell me a little bit about how that works, which leads you to speak with such passion on this topic.
Certainly. Thank you for that question. So there is no authorized agency provision as there is in the Vermont bill. In the New Jersey bill, there's a narrower one for guardians of incapacitated individuals and people like that. So we are not the authorized agent of any of the individuals in New Jersey, to my knowledge. One of the challenges that faces a covered person when they seek to remove their information from places where threat actors can find it is that, as you heard Jeff Jokic talk about, the ecosystem is immense and enormous. And one of the first things that we had to do to help people was try to map that ecosystem out. We were not as successful as Jeff. We don't have 8,000 data brokers in our system, but we have a little under 1,000. And so one of the things that we do for a covered person when they create an account with us is we surface that list for them, and we give them the choice of who they might want to send a takedown notice to. And that helps them illuminate areas of threat that they may not otherwise be aware of, or that might otherwise be hours of research for them to try to understand. But ultimately it's their choice. And yes, each individual elects what composition of data brokers they wish to send a disclosure request to.
So it is not the case that one signs up and then Atlas takes it from there.
No.
But, okay, so there's a lot of dialogue back and forth between your organization and the individuals as to, I'm just sort of trying to understand.
You could classify it that way, I think.
Okay. What that experience is like. And I am sort of hoping to hone in on what I feel is some tension between choices and when we make them, and with knowledge or with the information that we presume goes into making an informed decision and things of that nature, which I think I see happening in a couple different ways. And so I appreciate those thoughts.
Do you charge any of the clients to perform these services?
We do.
And Edie hasn't spoken.
So one of the things that I heard from a few people is if this were just a regular Daniels law, I would be okay with it. So what does that mean? And what are because I hear that in other testimony about other things, and I'm just so curious, what are the differences here? What are the touch points here that work as an expert with Daniels law?
We all get to be an expert in something, and this fell to me. So that's a great question. One of the strategies that many of the bad actors in the data broker ecosystem will engage in is once they recognize there's enough public support or political support for a type of bill, they will front run a defective version of that bill. And you see this in privacy across the country. Anytime you hear, just follow the Connecticut model, that's a defective privacy bill. And that's what that is. And that's what that is. And I guess if you're in that world, that's a smart strategy, right? Pass something and then say, oh, well, let's see how what we have is working before we reopen the bill. And unfortunately, that's exactly what has started happening with Daniels Law. They have front run Daniels Law in states like New York and in Maryland, where it's not named Daniels Law, it's named after Judge Wilkinson, who was killed at his home. And they have, in my opinion, made those bills defective. And that's not just my opinion, that's an opinion shared by many of the covered persons who, in theory, have rights under those bills. So New Jersey's Daniels Law is the strongest. It is the most effective. It has now been litigated, as you heard elsewhere, in court and found to be constitutional in what is now a published federal trial court decision, which means that precedent is binding. And that's the backstory there. So I can share a lot of anecdotes, but I'll leave it at that. It's a sad situation and one that we hope, if we have enough time, we can help remedy.
So 2 more questions. How is this different from Daniels Law? How
Well,
is this different from New Jersey?
So some of the differences are unique to how Vermont's statutory construction works. So that's the first thing, is no 2 bills will look the same because it attaches to different parts of the bill. The New Jersey Daniels Law covers both private and public records. This bill only deals with private records. The approach that we would endorse is get private protection in place for individuals now, and then seriously look at how to include public records redaction and protection for folks. A private bill such as this typically is more of a one-size-fits-all solution, meaning any state, regardless of their, other than drafting differences and definitional differences, regardless of their inner workings in the state, can put this in place, and it gives their covered persons the right to make these requests to external data brokers. Public redaction is much more bespoke. It's much more custom. Each state has its own voter transparency laws, its own OPRA or FOIA laws, and you have to navigate and step through all of those. It also can require a budgetary allocation to set up redactors within the state to help monitor the system and things like that. So that's another difference between New Jersey's Daniels Law and the bill in front of you today. There's another difference. The definition of data brokers that Vermont has that's referenced in this bill, cross-referenced in this bill, is much narrower. There's a rare point of agreement between Sarah O's from the CDIA and myself, where yesterday I heard her say it's not expansive enough, or at least treat everybody the same. I agree. And I think there's an opportunity to put in, very simple language that makes clear who is intended to be covered by this, that goes off of that cross-reference to the other statute. So that would be another difference. And again, there are other language that, because of a state or a certain circuit that a state is in, may need to be included or not included. And I think those amount for the other differences in the bill.
So then the only other thing, again, you mentioned it in your testimony, but I think that we have to talk about it more. The number of lawsuits that Atlas has filed. And I'm curious on a couple of notes, right? What you said was, with every one of these groups, you had multiple interactions with them prior to filing a lawsuit, and that they were not responsive until you did file a lawsuit. And I want to make sure that that's an accurate understanding of what you said, or am I misinterpreting what you said?
The interactions I referenced were not uniform. So we did not have those types of interactions with every single company that became a defendant. We did have evidence of non-compliance in every case where we brought suit against a defendant. So if we weren't sure, then we would not bring a lawsuit. We had to have pretty hard evidence or extreme implication that a company was disregarding its compliance obligations in order to support bringing a lawsuit.
I'm a big fan of cure periods. I think that there are circumstances where a business isn't aware or what they have done or hasn't put into practice yet the things that they need for you to be in compliance. And I'm curious what your view is on cure periods in this instance.
In theory, cure periods can seem like a good idea in a case like this. In reality, what we saw, not in a formal cure period, but in a similar instance where an individual would try to reach out and essentially say, you're outside of the window of compliance. I would like not to have to sue you, but would you please respond to me? What we saw in those cases was that certain data brokers, and again, this weights more towards the bad actors, would retaliate against those individuals, particularly in cases where there was a private search site that you had to go on and pay $5 or $10 to access. In some cases, individuals got threatening letters saying, we have banned you from our system. So imagine, in the context of a hypothetical cure period, you're a covered person here in Vermont, and you gain access for $10 or $20 to one of these private public people search sites. You find your name 35, 40 days after you sent them a non-disclosure request, and you find your name there, and you send the company, maybe because it's a requirement under this cure period, you send the company a notice and you say, here's my printout, please remove me. In those cases where similar behavior happened, we saw the companies retaliate, as I say, and send threatening letters to those individuals, closing their accounts, banning them from ever accessing the system again, threatening them that if they did, they would be prosecuted under things like the Computer Fraud and Abuse Act, and other types of language like that. And these letters scared people. You know, these were from serious law firms making serious allegations. And so in this case, there may be other safe harbors or standards that bad actors would not be able to exploit. But in our experience, a cure period is not one of them, unfortunately. And if you, and where we see cure periods to be most effective is liability that accrues with no notice at all. So if I'm a business and something, you know, the weather changes and I have some obligation and I didn't realize it, a notice under a cure period would be the first notice I ever receive. And that's appropriate, perhaps. In this case, the company has already received a notice, which is, of course, the non-disclosure request that the covered person sent. Does that help answer the question?
Just before, so just to, well, to go, just to expand a little bit, the things that we heard in testimony was that, you know, on 10 days, on the 11th day, he dropped 150 lawsuits. Or dropped 150 different notices that needed to be complied with within 10 days at Christmas time. And there was no way that that was going to be able to happen.
There's a lot to clear up there. I can start by saying every case we have ever filed is public record as part of the docket of the state of New Jersey or the docket of the Eastern District of Pennsylvania, the federal court where some of the cases were removed. You can go on and I'm happy, I think, as long as it's permissible. I don't know why it wouldn't be. I can send copies of them to you to read. It's all there. It's all there. Read the pleadings. You know, read some of, as another witness suggested, I don't think he meant it this way, but read the motions to dismiss that some of these defendants have filed. In their own words, listen to what they assert as their defenses. You know, we faced an incredibly strong facial constitutional challenge in federal court. We spent, and this goes to how the little guy really stands no chance. And but for our fortunate position, this would have died on the vine. The first thing that the defendants did in federal court was bring in the most expensive attorneys they could. And the first day I was in federal court, I walk in, there are 90 lawyers in the room, the Mitchell H. Cohen Courthouse in Camden, New Jersey, 90 lawyers, 5 on our side, 85 on the other side. And they mounted what's called a facial constitutional challenge to Daniels Law. They said it's not constitutional. Same thing you'll hear from everybody here. What a noble purpose. We wish it was constitutional, but it's not. And then they just chip and chip and chip away at it. And the judge disagreed. But just that battle cost us almost $10 million to fight. And there are many more battles like that to come. So again, there are a lot of mistruths, a lot of just outright fabrications that are out there. The clearest record to look at is the actual court filings themselves, both ours and what the defendants responded with.
So I'm looking at a fact sheet from New Jersey about what Daniels Law is, and request of redaction of certain personal information from public-facing state, county, and municipal websites. One, when we talk about Daniels Law, we're not talking about business to business. We're not talking about those $5. Is that correct or no? Those $5 search fees.
Well, this is a good example of how bad actors exploit loopholes to get around any enforcement of the bill. I'll give you one quick example, which may help illustrate it. You've all got computers. Google the word data tree. You heard a witness from this company earlier today. If you Google Data Tree, this is the title company. They operate a data broker subsidiary called Data Tree. It's the first result on Google if you look for them. And they self-advertise instant access to the nation's largest property record database. So is that, if I can go and sign up, as has been memorialized in the press, as Representative Priestley alluded to, if I'm a disgruntled individual looking to track down and harm a public servant, a judge, and I can go to Data Tree for $5, pull that person's information. Is that a business to business transfer or is that a business to consumer transfer? And in the case we had in Pennsylvania where the individual was a small business owner, if all I have to do is put in an EIN number, which I can get from irs.gov in 35 seconds, or at least I used to be able to do it. I don't know these days. Is that really, keep it up. Is that really any meaningful difference? I would argue it is not. And so that's what you run into when you start trying to talk about business to business versus business to consumer.
It's hard for me to, I mean, the actual amount of work that would have to go, and I know you say it's like 30 seconds, but you actually have to like spend time thinking about getting an EIN number to do that. And it's not as easy as just, at least based on interactions that I've had with people getting EIN numbers. I don't think it's like super easy just to like go onto the IRS and just get an EIN number. I mean, there has to be more to that, but maybe I'm wrong. I could be wrong.
Yes,
But so Daniel's Law, it is for municipal, for state, county, and municipal websites. So as we're talking about this is far more comprehensive, right? Because we're talking about business to business transactions. And again, this Daniel's Law is focused on the individual, not a business. And when I look at this legislation, this does have the implications of business to business, which is a huge problem for me. Is that the intent, is to go after business to business?
Again, the intent of Daniel's Law is to cease and restrict the availability of this information that is used to target and harm people. I think what you may be reading, and there are a lot of public websites in New Jersey that put out different types of information on Daniel's Law. I think what you're reading is the public redaction side of the bill, which allows for covered persons within the state of New Jersey to request redaction of public records, voter rolls, property tax rolls maintained by municipal record keepers and things like that. Then there is a second and separate provision dealing with private data brokers, which includes business to business transfers and other types of transfers of that nature. So the Vermont bill is not as expansive as the New Jersey bill.
Okay. And would you feel more comfortable about the business to business transaction side if there was a clause in there about know your customer, right? So if I want to do business with whatever company data broker that's out there, they would have to know that I'm a legitimate business doing legitimate business stuff. And then make it so that it does not affect businesses if it has that clause in there.
It's an interesting idea that one of the challenges is that KYC, know your customer, or KYC AML laws really only ask one question, which is the person who is trying to sign up actually that person? So, and I'll go back to the actual example that informs our view on these types of legislations now. In Pennsylvania, there was an unstable individual who was part of a case that a federal judge oversaw. He was a small business owner predating his involvement in the case, so he already had a small single person business. He developed a grudge against the judge. He bought firearms. He made very explicit threats, and he intended and had the ability to go to that judge's house and hurt that person. And he was criminally prosecuted, and I believe is still incarcerated. In that case, that individual signing up for a data broker site, all a KYC check would do is say, are you actually this person? And in that case, yes, I am this person. It doesn't restrict in any way his ability to, or her ability to get that information. So it would not be effective in actually protecting people. And again, we always try to go back to first principles when faced with questions, informed now by real world scenarios where we've seen individuals and families threatened and harmed. And we try to ask, would this help increase protection, or would this decrease protection and create loopholes that people can exploit?
So I think in your testimony, you had a couple of pieces where you had some suggestions for language. One was in the area of that page 8, B7, I think it was, which I guess is kind of what's referred to as safe harbor. And I think you made a reference to some suggestions. Is that something that you can offer us? And the other area, I think, was you had some question about the definition of a data broker and maybe some suggestions about that. Be interested in seeing that in both of those pieces.
Yes, sir. Okay, yes. I can provide those to the committee. Again, I am not a lawyer. To be clear, my understanding of the other member who just stepped out of the room, of her example of an individual actually going to initiate a transaction and agreeing to some legal terms that waived any ability to take action against any vendor involved in that transaction. I thought that was a pretty clear example of, a very easy to follow.
Yeah, because I think, some of the other witnesses said, well, this will impede, and the safe harbor doesn't cover, sort of the ordinary kind of transactions that people expect to be able to do. And, so any clarification that would help in that regard, I think would be good to see.
I'd be happy to work on that language if it's helpful. Yes.
I'm something that's come up a lot is the phrase good actors and bad actors, and I'm getting a little bit uncomfortable not really knowing who the good actors are. Can you list some of them?
Well, good actors would be data brokers who comply with privacy laws. One of the, and again, it's
Do you have examples of those?
So it's a common refrain is in our cases is, I received 10,000 notices in a short period of time. I didn't know what to do with them. The reality is 80 million Americans have the right to assert privacy rights today. California has had a statewide privacy law for 6 or 7 years. These are not new ideas. Daniel's Law was on the books for 4 years before we ever, before any of this dust ever really started getting kicked up. And a good actor, I would define as somebody who put in place the ability to receive and respond to California Consumer Protection Act requests and who registered with the appropriate data broker registries and who makes the effort to understand the regulatory landscape of what is now, I think, 19 states that have pretty comprehensive privacy laws. And even a state like Connecticut's does impose some obligations on the data broker. So what we've found there are some data brokers who actually made the effort to put all that infrastructure in place. And therefore, it really wasn't much of a heavy lift in some cases to simply honor those requests. And then other data brokers treated every privacy law as a suggestion and not a legal obligation.
It feels to me like it'd be very good to hear specifically from those entities and to know who they are. Because if there are good actors, it'd be nice to know that's the case, and here's how they approach these things, because that seems, I feel a little bit like we're characterizing some of the conversation that we're having, where we hear about assaults, murders, and horrible crimes. And I'm trying to understand, do we consider those failures of legislation? What is our success rate with respect to, it's a counterfactual, right? You never know what the harm that doesn't come to pass. But I'm just wondering if we can talk a little bit about, is there are we defining success through the number of PRA hits that we get?
That's a great question. And I spend a lot of time thinking about that question. As you allude to, it's very hard to prove a negative. How do you prove that someone didn't get murdered because of your efforts? And what I can tell you is that if you look at just the level of fear that these families live in, and I found this and lived in this world in New Jersey and still do, and I'm sure you'll find the same thing in Vermont. It's a small state. I'm sure many of you know law enforcement officers and prosecutors and judges. Go ask them and say, do you worry about this? And does it make you a little bit nervous? And have you ever dealt with this? And what my experience firsthand in New Jersey was, fear is endemic. And fear is not a thing to be afraid of or ashamed of. It's, as Gavin DeBecker says, it's the gift of fear. It's that heightened state of anxiety that keeps you alive. almost every law enforcement family that I got to know felt that on some level. And we used to do trainings at correctional facilities, and they would work 3 8-hour shifts in most cases. So we'd get there at 5 a.m. and we'd leave at 12:30 at night to make sure we got all 3 shifts. We'd sit in the muster room or the break room or wherever they'd have us, and we would educate people as to what this law could do for them. And I used to ask people, Burlington County Corrections in Burlington County, New Jersey was the first place we ever went like this. And I was asking people one after the other, have you ever been threatened? And the delegate pulled me aside and said, Matt, you've got to quit asking people that question. You've got to understand everybody who's been doing this job for a few years the right way has been threatened. That's one of those moments you just don't forget. And so to me, the success of Daniel's Law, implemented properly, is a reduction of that fear and anxiety. It's a feeling of safety and well-being, where if you're a public servant and an inmate makes a snide comment at the jail, or you pull somebody over and you have that uneasy feeling, or you're a judge in a case that really makes the hair on the back of your neck stand up, you're a little less worried about it following you home. And I think we've been able to achieve that in New Jersey somewhat, not fully because our litigation is still underway, but that ultimately is what I think we will define success as, is people feeling safer at home, as they should. It's a great question.
Can you just walk us through the process of your clients? You're working with them, they want to redact their main phone number. Are you does this turn into a blanket redaction through all data brokers? Are they picking and choosing which data brokers they want to? Because and then are the data brokers they're choosing, do they have different businesses under that they operate, that so they may operate with a credit reporting agency, or they may operate with financial institutions, they may operate with insurance companies, and so within that realm, are they able to redact it from certain places, but other places no, because they're doing these financial, they may want to do financial,
So let me take the second part of the question first. There are a lot of businesses that will have one well-known part or unit of the business, and then they'll have other parts of the business under that umbrella. And some of the CRAs are a great example, where you'll have a consumer reporting or credit reporting agency that's well-known. I won't name any, but we all know what they are. And underneath that entity, they will have people search databases, investigative tools, skip tracing databases, and things like that. And in my view, it can be very difficult to get them to speak honestly about what their different businesses do and how an individual might interact with one business unit versus another. And I think some of that may be intentional and may be purposeful in order to frustrate the assertion of people's lawful privacy rights. To the first part of the question, the way our system works is pretty simple, and it was informed really by 2 challenges that individuals had. One was, how do I know who all the data brokers are, who I should care about? Jeff's list didn't exist yet. We put together that list to help inform people. So these were data brokers, and we were able to audit their public-facing material, and to our satisfaction, they clearly fell within that definition. There were 936, I think, that we had on our list, just under 1,000 today. And then that was the first challenge, is just a knowledge challenge. And then the second challenge is, it goes back to retaliation. We witnessed how when individuals would try to assert privacy rights using their personal email addresses, they would become subject to retaliation. They would be signed up for spam email lists. They would receive, marketing emails they didn't want. It was sort of the ultimate irony, right? Please opt me out. Okay, well, either because the data broker is malicious or spiteful or just incompetent, or for whatever other reason may have been at play, that individual gets added to even more lists that they don't want to be added to. And so we built our system to be an email service provider like Gmail or Proton Mail, where the individual gets an Atlas Mail account that's meant to shield their personal email address from that type of retaliation and retribution. And so the process, therefore, when somebody signs up with us is, we collect information from them. They have an Atlas Mail email address created. And then they're given choice about who they want to send takedown notices to. They're given information and choice. And again, if you go back to the public record to dispel a lot of myths that are out there, another myth that we jumped out of the bushes on business day 11 and said, you're served. Never happened. And again, go to the record. It's easy to dispel that. If you look at the record across all the cases, the user counts, the number of assignors that we represent as the assignee of claims is different in almost every case. And some of that is a reflection of people making different choices at different times about what they wanted to do with their privacy. So that's how the system works at its foundational level.
Just wondering, there's the credit reporting, there are legitimate reasons why you want your name, your address on there. Where they may be running another side of their business is creating databases that you can find people's names and addresses to. Is that a different business? Are they running it as a subsidiary? Is there a way that people are able to keep me off of that list, but keep me on this list, or you're not opting out on that part of it, you're only opting out on that part?
Some of the answers to those questions may be up to how a company is willing to respond and engage with individuals. And this, again, I think in just our experience, you can see good actors and bad actors, good actors who reached out to people trying to engage, and bad actors who said, well, we're going to, we allege retaliate against folks and really try to harm them and punish them for having the audacity to assert these rights. Credit is a fascinating and complex part of the data broker ecosystem. My understanding is there is the actual credit file, and that is primarily composed of a credit score and other information around it. But when you think about freezing your credit, you're freezing the ability for that score to be released and for new trade lines to be opened. Then there's something called the credit header. The credit header, which contains the home address and the phone number of the individual, is not restricted by a credit freeze. The CFPB has been trying to restrict it. I think the odds of them succeeding now are probably 0%. But that is an avenue that we see as a potential threat vector. There's a lot of press that's been put out. You can, again, Google it. Don't take my word for it, where you can go onto the certain parts of the internet and the dark web, and for $5 or $10, you can buy access to any American's credit header and get all of that information. Actually, their credit report also, if you're willing to pay a little bit more, I believe. But the credit header data is a principal threat vector. And so, if you're running a CRA, I think, and you're trying to help protect people who are vulnerable, you've got to look at these different parts of your businesses and be honest about what the differences are, what data is included in each one, and so forth.
I'm sorry, I'm monopolizing. The lawsuits that you did down in New Jersey, you're not alleging that all of the people that you sued are bad, correct? Because I pulled up the lawsuit and some of the names on here: Oracle, Remax, TransUnion, Equifax, LexisNexis. I wouldn't, assuming that they're not, would not assume that they're bad actors. So, and I mean, I've obviously done business with some of them, right? TransUnion, Equifax, I'm sure everybody in here has probably done some sort of business with that.
I would say this: I would encourage you and everyone to go read the press and the public filings that have been reported on, or the stories that have been reported on, or some of the public filings that have been made against some of those companies you just mentioned, not just from us or about us, by about other and from other groups as well. And I would I would read and I would draw your own conclusions about some of the behavior that you may read about and how it reflects on who's a good or a bad actor. So
Would you mind sending us the? I don't know if what I'm looking at is correct.
happy to follow up with that material. So get the fireplace ready. You're in for an interesting read.
I just want, so in the course of like 3 questions worth of time, I was able to go onto Spokeo and pay 95 cents, sorry, and pull records on multiple committee members, including with permission, looked up Edie's address. Even though I don't need permission, I can go on and get everybody's backgrounds. For another $19.95, I can pull your like background report with much more information. This has all of my addresses I've ever had in my life, my phone numbers, my emails, my family, 35 of my family members. So that's great. So that's, I mean, that's super creepy. And that's one of hundreds, if not thousands of people search websites. I know when we were working on the privacy bill last year, I basically like worked with multiple members to work on like pulling their own records so they could see, in that case, like if there was incorrect information they wish they could fix because it would affect your credit history and that kind of stuff, or rating and things like that, and loans. I guess, Matt, in the end, like, why should we do this bill?
Well, first to I think the point that Representative Cooper made, imagine if you are a judge with a credible death threat or a prosecutor with a credible death threat and a family member you live with pulls up that same report. We've had that happen. Imagine the utter lack of safety and integrity in your own home that you would feel. And that's certainly ever present for a lot of these folks. Why pass the bill? Again, Vermont is, I've come to appreciate in the last 72 hours, is an even smaller state than I thought. People know each other and things work a little differently here. So I'd say hopefully over the last 3 days, the testimony you've heard at least opens your eyes to the threat that your friends and neighbors are under. And again, in a larger state, some people may be isolated. They may not know a judge or a prosecutor or a law enforcement officer or a correctional officer or a DCF worker who has to go into troubled homes and take kids away from abusive parents. I only know many of these people now because I spent the last year, a year and a half trying to help them. And here I get the feeling you all kind of know those people. They're your friends and your neighbors, and you kind of can't avoid them, whether you want to or not. And so the reason to pass the bill, I think, would be, one, if you believe what you've heard about the threat is real. If you don't, go talk to those folks. And then 2, once you become convinced of that, if you do you want to protect the folks you live with, your neighbors, and help keep them safe so that they can do a tough job for the benefit of everybody else? That's ultimately what all this boils down to. We need great judges who feel free to rule impartially without fear of intimidation. We need great prosecutors. We need great public defenders and great correctional officers. And the more you work to protect these public servants, the more qualified public servants you will get, the longer they will stay on the job, and the more confident they will feel in doing a great job, which is what everybody in Vermont deserves.
A follow-up, thank you. And why are you personally doing that? Like, why are you, here?
I knew when I got here, but after 3 days, it's a good question. I think I started this work out of curiosity, which is a primary driver for me. I tend to get into things because I'm curious and I like to learn more. And at some point, and then I like building things. That's my history. I don't really like litigation. I view litigation as destructive, although as one of the previous witnesses very eloquently put, as I said, it can be very effective, not necessarily efficient, but it can be very effective. So I always liked the opposite end of the spectrum, building things. And that was definitely my orientation. So in the course of building this, at some point, at some kitchen table, it changed for me and my partners and for a lot of the people involved in our effort. And it became about helping these people who really nobody else is looking out for. And we, not to get hocus pocusy about it, but whether, God or the universe calls you to some special work, I do believe that can and does happen. And we found ourselves, my partners and I found ourselves in in a state with a group of people who were being terribly threatened. We had the skills, the abilities, and the resources to do something about it. And at some point, we got the conviction and just put our foot down and said, come hell or high water, we're going to do everything we can to get this done. That's how I was raised. You don't quit. As long as you believe in something and it's ethical, legal, and moral, you don't give up, you don't quit. So although you often wish you could, but you just don't.
Thank you.
Thank you, Mr. Chair.
Thank you for joining us and thank you for your patience. Listen.
Yeah.
Really don't know how far we can get. The crossover tomorrow, but I think this is a subject that we continue to work on if we don't get it through tomorrow. But I think we have time tomorrow to take some, I think we need to sit down with our attorney and have some discussions of what the language does and doesn't do. And what other changes we can make sure that people are still able to purchase vehicles and purchase property and make sure commerce can continue to function, but still protect our public servants as well. So thank you, everyone. Judy, thank you for your indulgence for the second time.
It was maybe gonna be three.
I remember my Any questions? So,
That's up for tomorrow.
so 9:00 back, we'll just have committee discussion of where things will be going. Well, on this, what we're doing this week.
Okay.
I want to know what you're seeing in other committees. Are there things that we should be focusing our attentions on as well that other committees are looking at? Remember that's a function you should be doing every week. And oh, by the way, Herb, good job today on the floor.
Yeah.
And yeah, so we don't have Helen this week, so begin at 9 instead of 8:45, but on the floor at 9:30. And then we get off the floor, we'll have Rick come in and start our conversation. Okay, we can go offline.